My dear friends, welcome to this Dharma Chakra channel. I'm Advocate Venkatasiva Kumar. Honorable Chief Justice of India, our beloved Justice Surikant, in the recent Supreme Court proceedings mentioned with regard to the tribunal functioning, he said that to the government that they are creation of yours and it's a headache for you and a liability to us. Now, if you go back, there is tribunals have come into stay, but their functioning is not very happy, particularly insolvency legislation. The nation has already lost more than 30 lakh crores of rupees of public money by way of haircuts. And no goal has been achieved as set. So, it was taken up, Honorable Chief Justice made this in various forums, but then this is a statement made by their lordships while sitting in the first bench. So this is a matter of serious concern. Now, Honorable Justice M.M. Sundaresh, who is the Judge of Supreme Court, gave a wonderful lecture in Madurai conference, wherein the lordships have explained why the tribunal's functioning is so poor. And he pleaded for a case to be made. You strengthen the High Court system, remove these tribunals, ineffective functioning of the tribunals. And then it will give a constitutional power to that. You have separate block. It's not that regular these things. Specialized judges can be formed. And then even the technical members, whenever you need, you can take. It's a beautiful idea, their lordship through. And he was highly critical of the functioning of IBC. Particularly, we had a great interaction about 45 minutes on the functioning of these tribunals. And the lordship is basically very inquisitive, love to listen and all. And as you all know, he is a judge loved by everybody, very pleasant. Is the meaning of a judge, how a judge should be. So that is one second inspiration for me. And I was Honorable Chief Justice of India in an open court proceedings. He told me, Professor, why don't you give suggestions? And let it be adverse, I'm ready to take. And he gave the email ID to me. So then from then every month we are preparing some articles based on interactions with everybody. In the larger interest, there is no personal motive and we don't want to talk negative of anybody. We have highest respect for every person. We are systemic changes, bringing in how to bring the systemic changes. Next comes my friend Mr. Ram Subramaniam, Justice. He did a lot of work on this functioning of the tribunals, particularly NCLT, NCLAT. And we had many times interactions right from the various judgments that were delivered with regard to commercial wisdom, not justiciable. He is very, very practical person. He himself gave one judgment saying that the resolution process is for sick companies, but that has gone to such a level that IBC itself requires that. And this was quoted by Honorable Justice SESHASAYEE, who is now the judicial member of the NCLAT. So, and we can find that the judicial flavor, what means a High Court judge, if he dons the NCLAT, how well he will adjudicate. Very pleasant, listens to all the parties with pleasantness, and gives importance to the viewpoints of everybody, but then sticks to his own thinking. So there is something to be done. Same thing, Honorable Justice Abhay Oak, who is considered to be one of the best judges Supreme Court ever had. I have taken lordships because I am suggesting a committee to be formed to explore my suggestions, and Justice Abhay Oak or Justice Muralidhar, any one of them or two, or the committee formed by them will definitely do a great job. And I'm coming to the suggestions very fast on these things. I'll give you a summary. This is the PowerPoint. We'll go through what is that I'm going to talk before you listen to my live case study experience, the reforming the tribunal system in India. Now, why am I making this PowerPoint presentation? The interactions with Honorable Chief Justice is wonderful judge. He's a complete judge. Very good knowledge in understanding the issues. One, lordships can spot the issues in a petition, problems, and is willing to do his best to address them. Chief Justice of India post is really, if you go to Supreme Court, everybody appreciates. But then the task cut out is too much. But let us hope lordships will consider. So then this is what I've said. This is the observation of Honorable Supreme Court published widely in the media. Tribunals are increasingly becoming a liability to the judiciary, and the system is now a headache even for the government. Why? There is a growing concern on the efficiency. Are you achieving the target set? Absolutely not. If you say insolvency legislation, a very senior counsel said it is like a garland in the hands of monkeys. You understand? It is just meant for advocates and then the other persons. That's all. The main purpose is lost. Time-bound resolution, revival of sick companies, and judicial overreach is the basic problem now. And there is no accountability. We need an accountability and high structural imbalance. Let us see the next one. What are the structural failures? Now, if you see this, the judiciary, when the NCLT is there, and then the decisions of the liquidator or any other stakeholders are tested, administrative orders are tested, judicial review. And judicial review is the process followed against the touchstone of law, not technology. Decision-making process is technical. You take that. Administrative authorities must take. But then judicial member is the core of the benches formation. But now you are appointing a technical member, a chartered accountant, cost accountant, and now you will find a lot of IRS and officials, IAS officers are coming. Administrative. We are not saying anything. I must tell you, in NCLT Chennai bench, I appear. We have technical member, Mr. Venkatraman, very, very knowledgeable, extremely knowledgeable, and his ability to explain, understand the issues is very high. And he will assist Sanjeev Jain sir in the adjudication. Their orders are very good. Every issue they take, they are very wedded to the procedure, the legal process. Then we have the bench 2. Ravichandran Ramaswamy sir is there, IRS. Their lordships, the honorable learned member has got fantastic knowledge. Knowledge means he's got that, not because IRS, basically intrinsic knowledge is there, he can give best solutions. But then being an IRS officer, the lordship is like administrative head. because he conducts the proceedings. Therefore, they basically administrative officers won't like to listen to the other side. Like somebody is to tell me, you are a teacher, you are one side, you only speak, you don't like to speak the others. That is the basis on which bench 2 functions. We have a judicial member, he listens very well, gives opportunity, strict, he proceeds. So, but then the bench is like this. So we are not casting aspirations on anybody, because I am making first suggestion that you have to abolish this technical members sitting on the judicial benches to adjudicate. Most times, if you see NCLT also earlier, I've seen the judicial member will do something and the technical member will write the orders. So now that is not the right thing, is what our research showed. Because there are, why the IBC legislation has failed, we are trying to understand. I may be wrong. And it is only one committee of headed by just Abhay or just Muralidhar. Sit there, they will be in a very good position. But these inputs for the Honorable Chief Justice to consider. That is one. So technical member, why should he sit? That the same salary, cost and all is there. You can have one more judicial member there. So that single judge benches, you have double, no? You have whatever today, 2 benches are functioning in Chennai. You can have 4 benches, single judge sitting, High Court retired judge. Then you introduce the roster system. Every 3 months they will keep changing. In the same Chennai bench or anywhere, you get cost effectiveness, disposal of the cases. Today, there absolutely no work. Just adjournment will take place. And the time-bound resolution discussion is gone long back. Therefore, the technical members can be there as a team. For every Chennai bench, 4 benches, let us say. Now 2 are there. Actually, they thought there should be 3 division benches. That means you can have 6 benches, single judges. High Court judge will definitely be better than a IRS or a retired CA and other things. So they know accounts that you can always get. Once in a way, only issues will come. And today, if you see Justice SESHASAYEE sir or Justice Ashok Bhushan, so they have such a domain knowledge on Companies Act, is insolvency. You understand? It's not somebody's job. Anybody can learn it. Therefore, you should have for 5 judges benches, 1 technical member team. He will be asked questions because they are giving adjournment. This once the issues materialize, they can find an opinion. So the first and foremost suggestion, as Honorable Sundaresh sir said in the open court in Madurai, just abolish these judgments. Waste. Again, the same bureaucracy, same IRS, same IAS officers, and all those things are coming into the picture. And many times they are not even judicial officers, advocates also, they are not there. I repeat that there is nothing, they are very good to me. My Chennai benches both are very good to me. So I am not having anything. But then unanimous opinion of the top people is that first to abolish the technical members, keep that single judge bench, so that you have more benches to dispose the cases, introduce the roster system, so that you don't have only one person sitting for 5 years. That itself breeds all the trouble. Corruption is not just taking money, passing orders in violation of settled principles of Honorable Supreme Court. I will discuss how NCLAT disposed one case, totally ignoring Supreme Court or any IBC law. The judge is, that's all. He believes he is the man, that's all. He'll say, otherwise go to Supreme Court. No care. Like that they are talking. So we can use the VC hearing. Because another problem is that some judges, not all, they exercise power without justice. That's creating tyranny. You want to go to Supreme Court, man? We'll see, he'll say. And Supreme Court is to be loaded with all this. When Supreme Court has already passed an judgment, you have to comply with it, whether you like it or not. You want the NCLT to comply with it, but you don't want to comply with the Supreme Court. This is another problem. But who will bail the cat? So there should be a system, the standard operating procedures, recording of the video hearings. That, see here, judicial independence is one thing. Who will control the judges? Nobody. They have to control, self-regulated. But they will be controlled if they know they are watched. The aggrieved party can complain with the video recording. The way the judge is howling, hitting, or almost, we had one technical member who retired. Used to become so angry that you make beat you also, like that extent used to be there. He was terminated, and there were a lot of cases of corruption or against him. The president of NCLT himself has filed an affidavit before Supreme Court that this fellow is a corrupt person. After 3 years, and everything is lost. So therefore, this to be looked from that angle. There are very good judges. They won't bother anybody, this is corruption is some phenomena. You can't attribute motives. So therefore, I am very clear on this. Now here, unchecked behavioral arbitrariness. I'm going to give you an example, live example of one small case. Recently, I appeared, and I'll analyze that case and how the judgment has been delivered. And this is the list for the Honorable Chief Justice I have to send. By seeing, you will be startled. The way it is adjudicated, the way shouting at the judge, the counsel. When a judge keeps shouting at the counsels, what argument he will do? And the client is watching in the VC hearing. When he finds the client is being abused, then he will change. Therefore, the entire system comprises of only few big lawyers. That's all. 5 lakhs, one appearance. Just mentioning a lawyer is taking 3 lakhs of rupees to 5 lakhs. That's reason is because they expect that we want solution. Crores of rupees is involved in this game. So why should you bother about it, about money? Somebody's money only is there. So that basic system, simple corrections. I repeat further that you have single benches. Now itself you have 4 single benches. All should be judicial officers retired. Judicial officers who have experience adjudicating the cases. Then you have a centralized technical members, 1 or 2, supported by a team, a small team, and opinion is taken and given. So the cost will be, instead of 4 technical members, 1 technical member will do, and he will not write the orders. See, adjudication is given to them means then there will be, today they enjoy equal powers. That is the point. So, further these people are there for 5 years. And I'll give you an example. Morning you go. But if you make a mentioning before Honorable Chairperson follows a strict procedure. Mentioning correctly, he'll listen. No fear or favor. He'll just like that. Mostly he will accept. But even he rejects, no, you can do like this. Then the same thing, Justice SESHASAYEE. These were people who threw him. Now there is another bench. If you go, first he will talk. Sometimes nicely, sometimes angrily, sometimes critical comments, and all types of things. Then you will feel, yes, my lord. Even he says you are a fool, I'll say, yes, my lord. It's like that. What else you can say? Because it is he who has to control himself. You understand? By abusing, shouting at the person. Understand? Many people we find, suddenly he will abuse the person. In one case, I was having an experience. I was sitting. Then the mobile rang. Immediately the judge looked at me and said, get out. Then I said, may I know why I should get out? Why? When the course person are there, why? I said, I'm not, sir, your own assistant's mobile. So he is such harsh, very difficult. And you all know about it. No, I have great respect, but then you have no right to go on abuse everybody. That's not the purpose. And we feel tired, afraid to appear. Luckily, I need not appear before him. So this whole law is, blood pressure. This is a. Then next, if you mention, no, sir, Supreme Court extension, High Court has given. That is, when proceedings take place before the High Court, the time taken, the High Court Chief Justice has set aside that time to be included. No, my point is very clear. Go to Supreme Court. I will not give. That is, you don't bother about a constitutional court. I am against that. That judgment is not correct. Like that. See, everybody is growing, but ultimately, good or bad, the order has to be obeyed. No. That's what Vijay Nahar's case, Honorable Supreme Court has said. No, in the guise of interpreting, you are passing a law, overruling the Supreme Court. It's not acceptable. That amounts to judicial misconduct. That's what the Honorable Supreme Court. But then who will bail the cat? 5 years you have to bear with the person. So therefore, there is a great need, Honorable Supreme. And you find when such a dominant judicial member is sitting, the technical member, in spite of knowing so much, he'll have to keep quiet. Just watching. If you ask only, no, he has to tell. You don't ask. If without asking you tell, then same fate as the counsel is getting, he will get. I'll impose cost. I will complain to the counsel. Like that, yes, they have power. They do it. And this needs to be addressed. You understand? So that is why the suggestions are made to Honorable Chief Justice of India. So now what is the final suggestion? Abolish ineffective tribunals. Ineffective tribunals. There are some other tribunals very good. And there is a case made out in these tribunals, commercial court tribunals, as Honorable MMSJ sir said. It's better to take this to the High Court. Because High Court judges may not have knowledge, but Bharat Chakravarti Justice is there. Sendil Ramurthy sir is there, they whom I saw appeared. They have fantastic knowledge. Fantastic knowledge, highly concerned, kind judges. But they won't stay more than 3 months. See, that is also a very advantageous thing. No, same 5 years you are sitting there. Then this is the inherent problem of this IBC legislation. So, this is a suggestion made by Honorable Sundaresh sir. So now this is the suggestion I am making. So judicial member and technical member presently, both have available write the orders and they can differ from each other, and there can be a third bench will be appointed. So technical member is as good as a judicial member. That's not correct. Technical member is required for assisting the judicial member. Judicial member will adjudicate, hear the parties. What is your grievance? What is your grievance? And then what are the findings? Then what is the law he'll apply? Now today that's not the case in many cases. Very few cases. Technical members will be are being used for writing orders. But sometimes 1 or 2 cases, technical member, it doesn't happen in NCLAT. No technical member takes control. Only judicial member runs this because High Court judges are there. But in NCLT, many technical members control the affairs. We are not saying they are good, bad or anything. Principally, whether it is correct. And judicial member, by virtue of his training, seeing so many cases sitting on the benches or being benches, judges, law, judges should be, not directly a lawyer. Still lawyer is okay, legal knowledge. We have a person without legal knowledge itself, not appearance coming there. So this is the best suggestion. Everybody feels cost-effective suggestion, monitoring these things, disposal, time-bound resolution. Excellently, it will appear. Let us see. Now, the NCLAT, like a division bench. Madras High Court is there, single judge, 2 bench judgment. Same thing, this also we can have. So I'll remove the technical members, put 2 judicial High Court judges. That is real balancing power. In one case, judicial member is sitting, technical member is very intelligent technical member, but then he kept quiet. The Lordship passed an order which is never saw in the insolvency law itself. And when the person is presenting, shout him down. Then finally the judgment, if you read, it will become like a recovery legislation. There they don't want to. Some people, MM Sundaresh sir, first time I appeared. He is so good. He will ask, this is your case, no? As I understood correctly? Okay. This is your point of view for that, no? Am I understood correctly? I think this should be the judgment. And the judgment will be in a conciliatory approach so that they will achieve the... Here they don't listen. If you tell, they will shout at you. And they will pass order totally in contrary. Who will challenge that in Supreme Court? The judge himself is telling you, go to Supreme Court. What is this? See, it is not a adversarial, no. We are not against the judges. We are pleading. And they are expected to hear. Everybody is in trouble. In the NCLAT, 10 cases also they won't see. That is admission. That means your case is admitted. Then for next 5 years, it will not come for hearing. Nobody is there to address it. Because everybody is equal judges. If you ask chairperson, he'll say, no, you have to deal with that. So he's a master roaster, but never it is applied. So this needs to be addressed by the government and take the inputs, form a committee headed by Justice ABHAY is my humble submission. So when you have two judges, then equal judges, you should not have junior, senior. And then there are VC recordings. The registry should record. Keep that record for 15 days. If anybody is aggrieved, they can have it. That will be an evidence. Because sometimes what you plead, the judge will write something else. The facts that you pleaded, they will write it oppositely. And that load of Supreme Court is so high, very difficult. You are complicating the system of adjudication. And therefore, huge, big lawyers will come charging for 1 minute, 2 minutes, 5 lakhs, 10 lakhs. Who will bear that cost? Right. This is what I'm feeling. Next. So then 5 NCLT benches are handled by panel of centralized technical experts. They will give their opinion on this. Then the judges may consider it and then pass the orders. So this is very, very important. Because even today, judgments are actually typed and delivered by the court officers because they will note down everything. The senior will tell, I think this will be dismissed, this will be allowed. So they will pass the orders. Then technical member is given adjudication power and all. That is another problem. No? Whatever the juniors are saying, only they are writing. So therefore, the purpose is not served. That is what the Ministry of Corporate Affairs should note. And this is very, very important. Roster rotation every 6 months. Then, you don't need to know. If you feel the judges are not comfortable, then you wait till that. That's what we all do in the benches. And then the huge thousands of crores involved and that person is sitting for long. We are not saying he will take money or other thing. He will be under terrible pressure also. It is not that the judges are bad. They will have terrific pressure. Sam, Dan, Ved, Dandopai will be used by the big people. So therefore, these things reduces systemic bias. Roster rotation every 6 months, ensure fresh judicial perspectives. New different dimensions to these things. The transparency and monitoring engine, that's the most important. Today, nobody, whatever you talk, okay, because you cannot record the video proceedings. And the registry doesn't record anything. And they continue to abuse you anything, pass any orders. And what is agitated is different from what is written there. And this is a basic problem. In the name of independence, they become too much powerful. Naturally, you need them to be highly independent. So how to balance this is needed for a lot of thinking. And even, you know, what happens, I remember when the judges pass wrong orders, first of all, judge position is also, there are two litigants fighting violently. And if the judge favors one person, the other person will become hostile, not against the adversary, but against the judge. So judicial process itself is a problem. My friend used to tell me, he's gone to Supreme Court, he told me, one person abusively wrote in about him. When I said, why he is doing, he said, no, I've done some mistake, error I've done, resulting in that order impacting his family. Therefore, he is abusing me. He is entitled to abuse me. My friend is a very dharma principled person. And every time he used to feel, yo, something wrong, something. Today, if you are abusing a lawyer, what a lawyer has done? The other day I was appearing. I was just about to mention. When your matter is coming to tomorrow, why are you mentioning? Because my matter is coming tomorrow, I'm mentioning. No, you don't listen. Even the judge is talking, I am listening. And so you feel terrible. Even 1 minute that abuses. Next day. Then you find the learned judge is not knowing the subject. How can you tell him? When you tell no, that's all. Then he passed the order wrongly. When we explained, no, then he said we will reserve the orders. Again he passed same order. Completely overhauling the judgments of Honorable Supreme Court. He never considered anything. Then my client is afraid. Supreme Court means he will get no pay. So whatever law is passed is completely not in line with the Supreme Court or the IBC legislation. Maximum number of orders are there in the NCLT, NCLAT. Actually, if you suggest Supreme Court judgment, you lose the case. That's all. That is the respect that is happening. Whether I am right or wrong, it is for the registry to keep somebody to test whether any complaint, nothing. The president of NCLT, in the last minute after all the 3 years gone, he is told Supreme Court in an affidavit that 15 out of 23 are corrupt. So what happened to the 3 years? Have you corrected the system? No. Who will ask? If you want to practice in this area, you cannot ask. Yes. So we need to have, first step is we feel that the video recording should be there by registry so that there is no tampering. Then 15 days, because whoever is aggrieved immediately can record it and keep it with them so that he can produce it. That should be an evidence. That should be an evidence as per CPC. And that will solve all the problems. And that will give you systematic transparency, verifiable accountability, drastic reducing, arbitrary functioning. Nobody will abuse you. Chief Justice also can see why you are abusing that person. Even ladies are abused. And that's all. Some people may like to abuse others. So instead of home, they will come to the court. Like that, many people are feeling. So far as I am concerned, I have never felt that. So I cannot. There should be some accountability has to be fixed. Now you have Donald Trump is there. He doesn't care anybody. But sooner than later, he can be impeached by the president. Another problem in IBC legislation is a high money legislation. No paper person is willing to, because they'll say, no, it's very high risk job. Or they will use our name, and then try to project as if we have done something. So those people who want to practice will never give interviews. And it's all, this is what we have seen. So whimsical or unreasoned orders. You tell something that judge will pass based on something else. And then what you will do? You will go to NCLAT. You don't know whether it will admit or not. And even after admission, it will take 5-6 years. By then, he will retire. There is no accountability. You feel bad. You feel the God should punish these fellows. What the God will punish them after 65 years? Right. Why should we think like that? For everybody, we have to think good. Right. Abusive or harsh behavior on the bench. This is very damaging because all the clients are watching. they will see some 4, 5 seniors when they go, they will give importance. So everybody is going after them. 3 lakhs, 5 lakhs, 7.5 lakhs, 10 lakhs per hearing. Crores of rupees, whereas the younger talent all are killed. And Supreme Court means as such nobody bothers about it. So far as the tribunal members are concerned, we have seen documented instances of tribunal bypassing established procedural norms, creating friction with established statutes and delaying outcomes. We are going to come out with, we'll present it in confidence to the Honorable Chief Justice of India on the what's really the way in which they are adjudicating some of the judges, but others are very good judges are there. Case data illustrating whimsical bench orders, erratic scheduling, and instances of harsh and unprovoked behavioral anomalies towards the counsels. Empirical breakdown of the mixed bench models, demonstrating how passive technical members and stagnant tenures correlate directly with the institutional bar. This is the problem. IBC is one of the wonderful legislations. Now, this is the reformed justice ecosystem. Constitutional high courts, 2-judge NCLAT benches, single-judge NCLT tribunals and litigants. The whole problem with this IBC failure is IBBI. They receive a lot of documents. They can now become part of the technical monitoring system because you have a technical member, 2 members, and IBBI, IIIPI, they will have inputs into the resources. Then they will give. There is no judicial powers to these people, but they can help them with data. And that is what is very, very important. And I hope this will be executive summary. 4 pillars of systematic overhaul. Reduce tribunalization where ineffective. Shift reliance back to established proven constitutional courts to cure the systematic bloat. Strengthen the high court-centric adjudication and vigorously expand the established commercial courts model. Restructure benches strictly to single-judge NCLT, 2 judges NCLAT formats. Pour technical experts centrally off bench. Pool the technical experts centrally off the bench. Enforce accountability through mandatory VC recording, strict 6-month roster rotations, and truly independent oversight authorities. Now, dear friends, as the Honorable Chief Justice is thinking, reform is not just optional, it is an urgent necessity. Judicial leadership has opened the door. The Honorable Chief Justice Surikant sir has said that in the open court, Mr. Kumar, Professor, please send it to me. I will do my best. Therefore, we have taken a lot of our time, and the time for constructive experience-driven implementation is now. So I'm Kumar, my friends, and I am teaching court crafting techniques. I'm just trying to explain all my students how to face these benches, and at the same time, parallelly trying to see something reforms can be brought in. And I wish you all the very best. Thank you. Thank you very much.